Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Financial Oversight and Management Board for Puerto Rico vs. Centro De Periodismo Investigativo Incorporated. In this case, the court considered this issue. Does the Puerto Rico Oversight, Management, and Economic Stability Act, PROMESA's general grant of jurisdiction to the federal courts over claims against the Financial Oversight and Management Board for Puerto Rico, and claims otherwise arising under PROMESA, abrogate the board's sovereign immunity with respect to all federal and territorial claims? The case was decided on May 11, 2023. The Supreme Court held that nothing in the Puerto Rico Oversight, Management, and Economic Stability Act, PROMESA, categorically abrogates any sovereign immunity the Financial Oversight and Management Board for Puerto Rico enjoys from legal claims. Justice Elena Kagan authored the 8-1 majority opinion of the court. If Congress wishes to abrogate sovereign immunity, it must do so using unmistakably clear language in the statute. The Supreme Court has found such language only in two types of situations: when a statute expressly states that it is stripping immunity from a sovereign entity, and when a statute creates a cause of action and authorizes a lawsuit against a government based on that cause of action. There is no such language in PROMESA, nor does it create a cause of action for use against the board or Puerto Rico. Even Section 2126A, which provides that any action against the Oversight Board, and any action otherwise arising out of PROMESA, shall be brought in the Federal District Court for Puerto Rico, does not amount to a clear intent to abrogate sovereign immunity. Justice Clarence Thomas authored a dissenting opinion, arguing that Puerto Rico lacks state sovereign immunity, which would make the question of abrogation superfluous. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kagan delivered the opinion of the court. A recently enacted federal statute establishes a financial oversight board within the Commonwealth of Puerto Rico's government. The question presented is whether the statute categorically abrogates, legal speak for eliminates, any sovereign immunity the board enjoys from legal claims. We hold it does not. Under long-settled law, Congress must use unmistakable language to abrogate sovereign immunity. Nothing in the statute creating the board meets that high bar. Congress passed the Puerto Rico Oversight, Management, and Economic Stability Act of 2016, PROMESA, to deal with a fiscal emergency. Puerto Rico's public debt had soared to more than the annual output of the island's economy. The Commonwealth could not service that level of debt through the bond markets, and it was not eligible to restructure debt under the Federal Bankruptcy Code. PROMESA offered a path out of the crisis, helping Puerto Rico to achieve fiscal responsibility and access to the capital markets. The idea was to set up a system for overseeing Puerto Rico's finances, while also enabling the Commonwealth to gain bankruptcy protections similar to those available under the Code. PROMESA creates, as its centerpiece, the Financial Oversight and Management Board for Puerto Rico. The petitioner here. The statute describes the 7-member board as an entity within the territorial government of Puerto Rico, and this court has affirmed that the board's structure, duties, and powers make it part of the local Puerto Rican government. Under PROMESA, the board approves and enforces the Commonwealth's fiscal plans and budgets, and supervises the Commonwealth's borrowing. The board also represents Puerto Rico in so-called Title III cases, judicial proceedings, modeled on federal bankruptcy proceedings, for restructuring the Commonwealth's, and its instrumentalities, debt. With one exception, PROMESA says nothing explicit about abrogating sovereign immunity. The exception is for Title III cases, and comes via the Federal Bankruptcy Code. PROMESA incorporates, as part of its mechanism for restructuring debt, the Code's express abrogation of sovereign immunity. But as to all other matters PROMESA addresses, Congress did not mention sovereign immunity. In particular, no provision states that it is abrogating any immunity the board possesses from legal claims. At the same time, several provisions of PROMESA contemplate that, even outside the Title III context, the board may confront legal claims against it. Most fundamentally, Section 2126A, entitled Jurisdiction, states that any action against the Oversight Board, and any action otherwise arising out of PROMESA, shall be brought in the Federal District Court sitting in Puerto Rico. And Section 2126C anticipates that those actions may lead to orders granting declaratory or injunctive relief against the Oversight Board. Under the provision, such orders cannot take effect until the litigation is over. On the flip side, PROMESA sets certain limits on litigation targeting the board. Section 2125 forecloses monetary liability against the board, its members, and its employees for actions taken to carry out the statute. And Section 2126E provides that no district court will have jurisdiction over challenges to the board's certification determinations, mainly decisions approving Puerto Rico's fiscal plans and budgets. The suit before us demands that the board release various documents relating to its work. Respondent Centro De Periodismo Investigativo Incorporated, CPI, is a non-profit media organization that has published many reports on Puerto Rico's fiscal crisis and the debt restructuring process. In 2016, CPI asked the board to turn over a broad array of materials, including communications between the board's members and Puerto Rican and U.S. officials. When the request went unanswered, CPI sued the board in the Federal District Court in Puerto Rico. CPI cited a provision of the Puerto Rican Constitution interpreted to guarantee a right of access to public records, and it requested an injunction ordering the records release. The board moved to dismiss the suit on the ground that, as an arm of the Puerto Rican government, it enjoys sovereign immunity. The district court denied the motion, reasoning that Congress had abrogated the board's immunity in PROMESA, particularly in Section 2126A's jurisdictional provision. While the parties fought over unresolved privilege issues, CPI brought a second suit seeking another set of documents. The board again invoked sovereign immunity, and the court again denied the defense. Orders in both suits were consolidated for appeal. The Court of Appeals for the First Circuit affirmed the denial of immunity over a dissent. The court began by citing circuit precedent that Puerto Rico, like a state or Indian tribe, enjoys sovereign immunity. It then assumed without deciding that the board shares in Puerto Rico's immunity, noting that CPI had not contested that issue. That was the board's final piece of good news, for the court next held that PROMESA abrogates the board's assumed immunity. Congress may abrogate sovereign immunity, the court noted, by making its intention unmistakably clear in the language of the statute. And Congress had done so? The court held, in Section 2126A, the grant of jurisdiction there unequivocally stated Congress's intention that the board could be sued in federal district court. The court found additional support for its holding in Sections 2126C and E. The former, the court reasoned, contemplates orders of declaratory and injunctive relief against the board, and the latter, in making certification challenges unreviewable, implies that all other claims against the board fall within Section 2126A's scope. Judge Lynch disagreed. She would have held that Congress had not adequately set forth an intent to abrogate the board's immunity, whether in Section 2126A's jurisdictional grant or in any other provision. We granted certiorari, and now reverse. The question on which we granted certiorari is whether PROMESA, and particularly its jurisdictional provision, abrogates the board's immunity. As thus framed, the question asks only about abrogation, while taking the board's underlying immunity as a given. That framing accords with how this case played out in the courts below. Because circuit precedent had settled Puerto Rico's own immunity, the lower courts barely addressed the question. Similarly, for the board's immunity, CPI never argued that the Commonwealth's immunity did not extend to the board, and for that reason, the courts below simply assumed the board's immunity before turning to the abrogation issue. We took the case on those terms, and we resolve it on those terms. That means we assume without deciding that Puerto Rico is immune from suit in federal district court, and that the board partakes of that immunity. We address only whether, accepting those premises, PROMESA effects an abrogation. The standard for finding a congressional abrogation is stringent. Congress, this court has often held, must make its intent to abrogate sovereign immunity unmistakably clear in the language of the statute. We have invoked that clear statement rule and applied it equivalently in cases naming the federal government, states, and Indian tribes as defendants. CPI argues that the rule should not likewise apply to Puerto Rico, citing Congress's plenary power over territories. But we have similarly described Congress's power over the tribes, and still demand that Congress unequivocally express an intent to abrogate their immunity. Our precedent thus conveys a consistent message. If a defendant enjoys sovereign immunity, which we are assuming the board does, abrogation requires an unequivocal declaration from Congress. The court has found that standard met in only two situations. The first is when a statute says in so many words that it is stripping immunity from a sovereign entity. Congress, for example, has provided that states shall not be immune, under any doctrine of sovereign immunity, from suit in federal court for patent or copyright infringement. Those provisions, we have noted, could not have made any clearer Congress's intent to abrogate immunity. The second is when a statute creates a cause of action and authorizes suit against a government on that claim. Take the Age Discrimination in Employment Act, ADEA, or the Family and Medical Leave Act, FMLA. We held that each abrogated sovereign immunity by authorizing suits against employers, specifically including governments, for violating the statute's provisions, i.e., for discriminating or denying leave. Or consider the Indian Gaming Regulatory Act, IGRA. We likewise saw an abrogation in its authorization of tribal suits against states for violating their statutory duty to negotiate about gaming compacts. True enough, none of those acts expressly declared sovereigns non-immune, as the patent and copyright laws did, but all expressly authorized suits against sovereigns in service of enforcing statutory requirements, and recognizing immunity would have negated those authorizations. The very suits allowed against governments would automatically have been dismissed. PROMESA fits neither of those two molds. Except in Title III debt restructuring proceedings, not at issue here, the statute does not provide that the board or Puerto Rico is subject to suit, and indeed the exception implies the opposite as a general rule. The immunity provision that PROMESA borrows from the Bankruptcy Code for Title III cases states, sovereign immunity is abrogated as to a governmental unit, including a territory. Congress chose not to adopt similar language to govern other kinds of litigation involving the board. 2. PROMESA does not create any cause of action, or otherwise approve any claim, for use against the board or Puerto Rico, so recognizing immunity under PROMESA would not, as in the ADIA, FMLA and IGRE cases, authorize a suit against a sovereign with one hand, only to bar it with the other. Instead, immunity would operate in the ordinary way, to protect a sovereign from suit. Those conclusions defeat CPI's theory of abrogation. That argument rests on the presence in PROMESA of a general jurisdictional grant. Section 2126A provides that any action against the Oversight Board, and any action otherwise arising out of this act, in whole or in part, shall be brought in the Federal District Court in Puerto Rico. That text, CPI contends, expresses Congress's intent to abrogate the board's immunity. But this court has rejected the idea that a general jurisdictional grant strips immunity. In Seminole Tribe of Florida v. Florida, for example, we held that an unmistakably clear abrogation cannot be inferred from Congress's conferral on district courts of jurisdiction over any cause of action initiated by an Indian tribe under the IGRE. And similarly, in Delmuth v. Muth, we held that a provision granting district courts jurisdiction over actions brought under an education law did not abrogate states' immunity. Those cases rest on a simple insight. A jurisdictional grant says nothing about the sovereign immunity defense. The grant enables federal courts to hear cases, but does not define the scope of defenses, including sovereign immunity, a defendant may raise. As a result, even the most capacious grant of jurisdiction will not, by itself, suffice to abrogate sovereign immunity. Section 2126A's jurisdictional grant does not do more than those in Seminole Tribe and Delmuth. It authorizes all manner of claims against the board in the Puerto Rico Federal District Court, but it does not show, much less unmistakably, that Congress intended for the board to be stripped of immunity. Indeed, as noted above, Section 2126A does not speak to immunity at all, and that silence is doubly telling here. Congress knew how to abrogate sovereign immunity in PROMESA. For Title III cases, it explicitly adopted a bankruptcy code provision doing just that. That express abrogation for one class of cases makes the silence for others more obvious, and less supportive of CPI's position. CPI resists that conclusion, arguing that Section 2126A's breadth and detail make it unlike a garden-variety jurisdictional grant. Section 2126A refers not just to actions against the board, but also to actions otherwise arising out of PROMESA, and it names, as the proper forum for all those cases, the Federal District Court in Puerto Rico. Those features of Section 2126A are significant, but not for the reason CPI gives. The language and specificity of Section 2126A make clear that Congress wanted to consolidate in a single court all litigation about PROMESA's operation. But nothing in that provision suggests, much less makes unmistakably clear, that Congress intended for those claims to proceed even when they would otherwise be barred by sovereign immunity. CPI also points to two other sections of PROMESA, Sections 2126C and E, to bolster its abrogation theory. As noted earlier, Section 2126C refers to orders of declaratory or injunctive relief against the Oversight Board, and Section 2126E strips district courts of jurisdiction over challenges to the board's certification decisions, whether brought by the governor or legislature of Puerto Rico or by any other person. According to CPI, those provisions would be unnecessary unless Congress had abrogated the board's immunity to at least some extent. But that is not right. The provisions make perfect sense without any abrogation. Recall again that a jurisdictional grant says nothing about sovereign immunity. So, Section 2126A can have meaning even if the board remains immune from most claims. Similarly, Sections 2126C and E can operate even if the board retains immunity. Section 2126C serves to delay a ruling's effect when the board loses an immunity defense or otherwise is subject to an action. And Section 2126E creates an absolute bar to litigation over board certifications, whether or not the board is immune. Those provisions, like the rest of PROMESA, give no indication that Congress has unequivocally expressed its intent to abrogate the board's immunity. We hold that nothing in PROMESA, not least Section 2126A, affects an abrogation of the board's sovereign immunity. We do not decide whether the board enjoys such immunity. We say only that if it does, Congress has not taken it away. We therefore reverse the judgment of the First Circuit and remand the case for further proceedings consistent with this opinion. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.